Welcome back to the Constitutional Clarion. This video is about whether the Senate alone could get a referendum to change the Commonwealth Constitution put to the Australian people, even though it was opposed by the government and not passed by the lower house. Most people who know about such matters would think that this was settled way back in 1914 and that any such referendum would be blocked by the Governor-General acting on ministerial advice. But I've dug up a document showing that the precedent is not quite what we think it was. So keep watching, because it turns out that this is actually a little bit more interesting than you might think. Let's start first with the Constitution. What does it say? Section 128 sets out the mechanism for amending the Commonwealth Constitution. The primary method for doing so is for a proposed law to be passed by an absolute majority of each House of Parliament. Then, between 2 and 6 months after its passage through Parliament, it shall be submitted to the people in a referendum. But there is an alternative method. Section 128 also says, and I'm quoting here, so it's a bit long-winded, that if either house passes any such proposed law by an absolute majority and the other house rejects or fails to pass it, or passes it with any amendment to which the first mentioned house will not agree, and if, after an interval of 3 months, the first mentioned house in the same or the next session again passes the proposed law by an absolute majority with or without any amendment which has been made or agreed by the other house, and such other house rejects or fails to pass it or passes it with any amendment to which the first mentioned house will not agree, the Governor-General may submit the proposed law as last proposed by the first mentioned house, and either with or without any amendments subsequently agreed to by both houses, to the electors in each state and territory. Yes, it was rather wordy, but what it really means is that if one house, and it doesn't matter which one, passes a referendum bill by an absolute majority and it does it twice against the wishes of the other house, and there's that 3-month period in between, it can be put to a referendum. Critically, it says that the Governor-General may, rather than shall, submit the proposed law to a referendum. This leads to the question of whether that may gives the Governor-General a personal discretion, or whether he or she is obliged to act upon the advice of his or her ministers. Before getting to the relevant precedent, it's actually worth having a look at the history of the drafting of Section 128 and the reason for including that alternative method. When the Constitution was being drafted, the first version of this provision, as agreed by the 1891 Constitutional Convention, involved proposed constitutional amendments being passed by an absolute majority in each house and then being put to conventions that were elected by each state. The use of conventions followed the United States practice, as there was significant distrust amongst the framers of the Constitution in 1891 of the idea of a referendum and the wisdom of the people voting directly on constitutional amendments. At the 1897 Constitutional Convention, however, that changed, with the idea of a referendum being successfully pushed by Alfred Deakin, amongst others. The new provision set out the method of both houses passing the proposed constitutional amendment by absolute majorities before it would then be put to a referendum. During the debate, Isaac Isaacs, on behalf of the Victorian Parliament, sought to ensure that if the two houses disagreed, a matter could still be put to a referendum. He said, "Suppose one house is of the opinion that a certain change is desirable in the interests of the people, and the other house does not agree. Who is to decide the question finally? Is it the house that negatives the proposal, or is it the house that affirms the proposal? Or is it, as we think, neither of them but the people themselves?" Those who opposed this change did so due to a concern that it might weaken the power of the Senate because it could not then veto a referendum proposed by the House of Representatives. And they were successful, so that the final version that was agreed upon by the Constitutional Convention in 1898 required that each House pass a proposed constitutional amendment by an absolute majority before it could be put to referendum. That's the version that was put to the people in the Federation referendums of 1898. But the referendum failed in New South Wales. Whilst it received a majority of votes of those who voted in New South Wales, the number of yes votes did not reach the required threshold of 80,000. Without New South Wales, Federation really couldn't proceed in practical terms, so something had to give. There was a Premier's Conference in January 1899 to consider changes to the draft constitution which had been proposed by the New South Wales Legislative Assembly and the Legislative Council. One of those proposals had been initiated by the Labor leader in New South Wales, James McGowan, who was concerned that it should be the people who determined any dispute between the houses on constitutional reform. The premiers at their conference unanimously agreed to a list of 8 changes. Number 6 on that list said, neither house alone should have a power to prevent a reference to the people of a proposed alteration of the Constitution. A proposed alteration, if twice passed by one house and twice rejected or obstructed by the other, might be submitted by the Governor-General to the people. This decision was accompanied by the text of the proposed amendment. It remains a mystery as to who actually drafted it, because there were no expert drafters who attended the meeting, resulting in some rather oddly worded amendments. But in the only description we have of what occurred behind the closed doors at the Premier's Conference, Alfred Deakin, who wasn't there but got his information from the Victorian Premier, claimed that most of the premiers wanted to take the opportunity to liberalise the Constitution, including widening the power of amendment by allowing either house to remit an issue to the electors. There was no suggestion that this was really to be a power confined to the House of Representatives or to be controlled by the government. Quick and Garran, writing in 1901, observed that once the procedure of passage by a house twice had been met, it, quote, becomes the duty of the executive government to submit the proposed amendment to the popular vote throughout the Commonwealth, unquote. They didn't appear to anticipate that the government might advise the Governor-General not to complete the process by putting it to a referendum. Professor Harrison Moore, writing in 1910, noted that asking the people to decide in a referendum when the two houses cannot agree on constitutional reform was actually derived from Swiss constitutional practice. Harrison Moore also compared the means for dealing with conflicts between the two houses of the Commonwealth Parliament over ordinary legislation, which under Section 57 of the Constitution can trigger a double dissolution, against the means for dealing with those kinds of conflicts in Section 128 about constitutional reform. There are similarities between the two processes, such as the passage of the bill and its rejection by the other house and the use of 3 months in between to ensure there's sufficient period of time for consideration. But there's also a major difference. The Section 57 process results in an election and a joint sitting because ordinary legislation is a parliamentary matter, whereas constitutional reform, says Harrison Moore, is a matter for the people. So it's right that they get to resolve any conflict over proposed constitutional changes by way of a referendum. Harrison Moore also noted that the Section 57 procedure only applies to bills originating in the House of Representatives and rejected by the Senate. But the Section 128 procedure, because it applies to deadlocks over constitutional reform, operates regardless of which house initiated or rejected the proposal. This is because both houses have their own particular interest in the constitutional system. Professor Pitt Cobbett, writing in 1919, also noted that relationship between Section 57 and Section 128 of the Constitution. He said in relation to Section 128, quote, "Where the proposed law is initiated by one house only, the question of its submission to the electors, as well as the inclusion of any amendments agreed to by both houses, is left to the discretion of the Governor-General. The fact that the amendment may be initiated by either house alone, by the Senate, that is, as well as by the House of Representatives, would seem to point to the conclusion that this was intended to be a personal discretion. Otherwise, in the case of divergence between the two houses, the action of the Senate would ordinarily be frustrated by a ministry dependent on the House of Representatives. On the other hand, the course of constitutional practice so far goes to show that the discretion is one to be exercised solely on ministerial advice." Unquote. What he was talking about there was the 1914 precedent. On that occasion, as a matter of coincidence, the Governor-General, Sir Ronald Munro Ferguson, faced the dilemma of how to deal with a double dissolution request under Section 57 of the Constitution, which had not occurred up to that time, and whether to put a referendum to the people that was passed only by the Senate and not by the House of Representatives, and was opposed by the government. The Cook Liberal government, facing frustration in the Senate, had deliberately cooked up, pun intended, a bill on minor issues which it knew would provoke Senate objection in order to manufacture triggers for a double dissolution election. Cook argued that the Governor-General was constitutionally bound to act on his advice and to grant him a double dissolution. He also said that if his advice was refused, his government would resign and the other side had no hope of maintaining confidence and supply, so a dissolution would have to be granted anyway. Cook argued that it was fairer to grant the dissolution to him rather than a successor who did not have the confidence of the lower house. The Governor-General, according to the ordinary practice, consulted the Chief Justice, Sir Samuel Griffith, about the constitutional issues. Griffith advised that the Governor-General could not dissolve the Houses other than on advice, but that he was not obliged to act on advice from ministers to dissolve Parliament. In other words, the Governor-General did not have a unilateral positive power to dissolve the Houses, but he did have a unilateral veto power over government advice to dissolve. Griffith described the Governor-General as an independent arbiter on such constitutional matters. The Governor-General told Cook that he did not accept his argument that the Governor-General had to act upon Cook's advice to dissolve, but in this case he would grant him a double dissolution because there was a genuine deadlock and no other government could be formed. He applied the usual condition that Cook would have to secure the passage of supply to cover the election period before a dissolution could be granted. Cook went back to Parliament and supply was passed before the Houses were dissolved. During this short period before the dissolution, while Parliament was still sitting, the President of the Senate presented an address to the Governor-General requesting him to submit to a referendum 6 proposed constitutional amendments, which he said satisfied Section 128 requirements by having been passed twice by the Senate and rejected twice by the House of Representatives, with that 3-month period in between. There has actually since been argument that the bills did not satisfy that requirement for a second failure to pass, but let's just put that aside for the moment. The proposed amendments concern the expansion of Commonwealth legislative power with respect to trade and commerce, corporations, industrial matters, railway disputes, trusts and the nationalisation of monopolies. The proposed amendments were very similar to those that had already been put to referendum in 1911 and 1913 and failed on both occasions. The short response from the Governor-General, which is published in the Senate's Hansard, was that he had submitted the address to his ministers for advice and that they were unable to advise me to comply with the request. The Governor-General stated that he accepted this ministerial advice and was therefore unable to grant the request to the Senate. This has been taken ever since as acceptance that the Governor-General has no discretion and is bound to act upon the advice of his ministers in such matters, unlike in relation to Section 57 of the Constitution, where discretion continued to be exercised. But, as I said in my previous video, I've been going through some archival correspondence of Governors-General, and what really happened is actually quite different. The Governor-General told the Colonial Office that his reasons for the refusal to put the bills to referendum were that 1. They were not relevant to the deadlock giving rise to the double dissolution. 2. They had already twice been submitted to a referendum and rejected, most recently only a year ago. 3. No reason had been offered for bringing forward the referendum for a third time within 3 years. And 4. That to decline the request cannot injuriously affect the electoral prospects of either party in the forthcoming election. In fact, the Governor-General had exercised independent discretion. It was simply the case that he came to the same conclusion as his ministerial advisers, so he accepted their advice. He did not accept the proposition that he was bound to act on their advice and had no discretion in the circumstances. The response given to Parliament was, however, drafted by the Attorney-General and appeared to give a different impression. So this is another example of what people believe are precedents arising from a lack of understanding of what occurred due to the lack of access at the time to the relevant primary documents. Now, there may be good reason why you wouldn't want to put the people to the expense and the division of holding referendums on any idea that was passed by the Senate. But it's fair to say that the precedent that people fall back on when discussing this issue is actually no real precedent at all. Thank you once again for watching the Constitutional Clarion, and as always, I look forward to seeing you again next time. Goodbye.